everyone. All right. I'm here today to comment on a class action lawsuit that was filed in Charleston County by Mary Beth Mullaney this afternoon, just within the last few hours. I'm going to first read you the complaint. Plaintiff Jane Doe, by way of this complaint, brings the below claims against Patrick Bryant, John Osborne, Eric Bowman, and Palmer Group LLC, collectively as defendants. Through her undersigned attorney, respectfully alleges unto this honorable court as follows. Plaintiff brings claims against defendants for wrongful intrusion into private affairs, battery, intentional infliction of emotional distress, premise liability, defamation, abusive process, negligence per se, negligence, gross negligence, and conspiracy. At all times relevant to this complaint, plaintiff was a resident of Charleston County, South Carolina. Defendant Bryant is a resident of Charleston County, South Carolina. Defendant Osborne is a resident of Charleston County, South Carolina. Defendant Bowman is a resident of Charleston County, South Carolina. Defendant Palmer Group LLC is a for-profit South Carolina corporation registered with the South Carolina Secretary of State and regularly conducts business in Charleston County. Bowman is the registered agent. Upon information and belief, Bowman owns and operates the company. Venue is proper for this judicial circuit because of the unlawful acts which are the subject of this complaint occurred in Charleston County. On February 10, 2025, South Carolina Congresswoman Nancy Mace, and I am not Jane Doe, by the way. On February 10, 2025, South Carolina Congresswoman Nancy Mace delivered a speech on the floor of the United States House of Representatives regarding a bill she introduced to combat voyeurism known as the Stop Voyeurism Act. This bill seeks to broaden the scope of federal laws against video voyeurism beyond federal lands, impose harsher penalties for offenders, and create a civil right of action for victims of voyeurism, allowing them to sue perpetrators. In her speech, Congresswoman Mace said, "Last year, I had to tell a woman she'd been raped. She had no idea because she was incapacitated when it happened. I knew because I accidentally found photos and videos of her assault. I saw one of Patrick Bryant's business associates, John Osborne, sexually assaulting her at the home of Eric Bowman. Patrick Bryant was present, and he and Eric Bowman both had their phones out during the rape. I found a video recording and photos of the assault on Patrick Bryant's phone. I would later learn these men planned her assault." Plaintiff is the woman who Congresswoman Mace, one of the women Congresswoman Mace was speaking about. Bryant is Mace's former fiance, and the plaintiff's former boss. He employed her. Bryant, Osborne, and Bowman are wealthy entrepreneurs, close personal friends, and business associates. Plaintiff is a young woman who between 2017 and 2019 was initially employed as Bryant's personal assistant, then worked for two companies owned by Bryant. In October of 2018, plaintiff was 23 years old at the time and was working two jobs. She worked for one of Bryant's companies during the day and had a second job as a server to supplement her income. On Thursday, October 25, 2018, at approximately 7 p.m., the plaintiff met a girlfriend for drinks at the restaurant where she worked. Because they offered her employee discounts and money was tight. Plaintiff and her friend sat outside the patio. Plaintiff noticed that her boss, Bryant, was at the bar drinking with Osborne and Bowman. Plaintiff had been on several dates with Osborne, who was married with two kids but separated at the time. Plaintiff knew she was not the only woman Osborne was dating. Plaintiff was familiar with Bowman because she had seen him at several company parties hosted by Bryant, and she knew he owned a local sports team in Charleston. Bryant, Bowman, and Osborne visited plaintiff's table several times and bought the women drinks. Around 9 p.m., plaintiff's friend went home. Plaintiff, Bryant, Bowman, and Osborne went to Home Team Barbecue on Sullivan's Island, where Osborne purchased drinks for plaintiff. Around 11 p.m., plaintiff noticed Osborne had left her at Home Team. She texted Osborne asking him where he was and if he was okay. Osborne responded by sending several angry and hostile texts. Osborne was angry at the plaintiff because he believed she was paying more attention to Bryant than to him. He texted, "Go blank and have fun." Plaintiff was taken aback by Osborne's text because she felt she was paying attention to him. Moreover, Bryant was her boss, and she was not interested in him romantically, and Osborne knew that. At approximately 12:15 a.m. on October 26, 2018, plaintiff, Bryant, and Bowman went to 3224 Marshall Boulevard on Sullivan's Island, where Bowman lived with Jane Doe witness and their children from previous marriages. The five-bedroom home is approximately 5,000 square feet, is across the street from the ocean, has a built-in hot tub and pool, and is owned by Palmer Group LLC, one of Bowman's many businesses. Bowman had video and audio cameras installed throughout the home, which were accessible from a cell phone. Jane Doe witness heard them come in. She accessed the cameras from her phone and could see and hear much of what happened. She was unable to see everything because Bowman turned the cameras off. However, Jane Doe witness turned the cameras back on from her phone. According to Jane Doe witness, plaintiff appeared to be very intoxicated and was barely able to walk or talk. Jane Doe witness heard Bowman and Bryant trying to coax plaintiff into one of the empty bedrooms. Plaintiff, however, went back to the pool deck instead. Plaintiff stumbled into the pool fully clothed and screamed loudly. Bowman and Bryant laughed at her and filmed her on their cell phone. Plaintiff then went into the house, took off her wet clothes, covered herself with throw pillows, and passed out on the couch in Bowman's living room wearing only a black bra and no underwear. Bryant and Bowman called Osborne. They told him plaintiff was passed out and needed to come get her. Shortly after, Osborne showed up. Jane Doe witness documented what she saw in writing that night in an email she used for her diary. Jane Doe witness emailed the diary entry to herself at 7:58 a.m. on October 26, 2018. Below are excerpts from her email. Then Bowman and Bryant went to take pictures of plaintiff, first naked, but covered with pillows. Then they removed all of the pillows while she was still passed out and took more photos of her totally exposed. They left her like that in the middle of the house and went back to drink in the kitchen. When Osborne got there, he joined them in the kitchen. They continued talking about why you bang some girls and not others and how they don't care who's married or not, and told Osborne that he needed to get plaintiff dressed because they didn't want to touch her. But before that, he should bang her on the couch while they watched. They decided to pour new drinks first, and Bowman killed the living room camera. When I turned it back on, Bowman and Bryant were sitting on chairs, both taking pictures, while John began kissing, fingering, and performing oral sex on plaintiff, who was still passed out. I couldn't believe what I was seeing. Bowman and Bryant took pictures on their cell phones of plaintiff's private parts while she was unconscious, wearing a bra and no underwear. Plaintiff did not consent to these pictures, nor did she have the capacity to consent when they took these pictures. Osborne digitally penetrated plaintiff and performed, I can't even say it, on her while Bowman and Bryan filmed it. Plaintiff was unconscious and did not consent or have the capacity to consent. Bowman, Bryant, and Osborne conspired to perpetrate several criminal acts against the plaintiff, violating state and federal laws. They agreed that Osborne would perform sexual acts on plaintiff, and Bryant and Bowman would watch him violate plaintiff and film it. The crimes that they conspired to commit include but are not limited to sexual battery according to South Carolina Code 16-3-651. Plaintiff did not consent, nor did she have the mental capacity to consent because she was mentally incapacitated as defined by South Carolina Code 16-3-651F. She was physically helpless as defined by South Carolina Code 16-3-651G. Bowman and Bryant and Osborne's actions against plaintiff violated criminal sexual conduct in the third degree. South Carolina Code annotated 16-3-6541B, which states a person is guilty of criminal sexual conduct in the third degree if the actor engages in sexual battery with the victim and the actor knows or has reason to know the victim is mentally defective, mentally incapacitated, or physically helpless. Defendant's actions against plaintiff also constituted assault and battery in the second degree as set forth under 16-3-600 D1B. Bowman, Bryant, and Osborne had a lewd and lascivious intent when they perpetrated these acts on plaintiff. These acts were perpetrated without her knowledge or consent for their own sexual gratification. Bowman and Bryant are culpable for the sexual battery perpetrated on plaintiff under the theory of accomplice liability because they planned to commit the sexual battery and were present when it occurred. At approximately 2 a.m., Bowman texted Jane Doe witness and instructed her to come downstairs and bring clothes, as one of Bryant's employees had come over, fallen into the pool, taken off her clothes, and passed out on the couch. Bowman was unaware that Jane Doe witness had witnessed their criminal acts in real time on the house cameras. Bowman and Jane Doe witness told Jane Doe witness he didn't want to touch plaintiff because she was naked, so she needed to dress the plaintiff in dry clothes. Jane Doe witness did as she was told, and she dressed the plaintiff. While Jane Doe witness was dressing her, plaintiff opened her eyes briefly. She looked scared and confused. After Jane Doe witness dressed plaintiff, Osborne left with the plaintiff. When she woke up, Jane Doe witness looked for the video of the sexual assault on the house cameras, but Bowman had already deleted the video. At 7:58 a.m., Jane Doe witness emailed a diary entry to herself detailing what she observed. She emailed it to herself because she was fearful of Bowman and did not want him to find the email. Plaintiff woke up in bed with Osborne at his residence on James Island wearing Jane Doe witness's clothes. Plaintiff had little to no memory of the night. Osborne told her she was drunk, fell into the pool, and Bowman and Bryant called him to come get plaintiff. He told her Jane Doe witness gave her clothes because plaintiff's clothes were wet. The next day, plaintiff texted a friend She met for drinks as she had blacked out and didn't remember much of the night. A day after the assault, Bryant told plaintiff he was planning on coming to the restaurant where she worked on October 28th and asked her to arrange for him to be seated in her section. Plaintiff told her manager that Bryant asked her to be seated in her section. Bryant sat in her section and left her a 50% tip. On October 30th, plaintiff had the following text exchange with Bowman on Telegram. Plaintiff: I have Jane Doe witnesses' clothes. How can I get those back to her? Bowman said, LOL, wear them over. Plaintiff said, and then jump into the pool. Bowman said, seems like some logical steps. Plaintiff: I wish I could remember. Bowman: you're destructive when you're smashed. It was hilarious, though. Plaintiff: did I wreck anything? I'm sure I was encouraged by the laughter. Bowman: no worries. You're 100% fine. You seem to be having fun. So we just sat and enjoyed the show. On or about November 1st, 2018, plaintiff texted Bowman and asked for his address and left Jane Doe witnesses' clothes on the doorstep. Bowman, Bryant, and Osborne concealed the sexual battery videos and photos from plaintiff for years. Defendants acted knowingly, intentionally, and maliciously with intent to deceive and mislead the plaintiff. After the assault, plaintiff went on a few dates with Osborne and stopped seeing him in December of 2018. At the office Christmas party in December 2018, Bryant and the plaintiff took luge shots together. The party featured an open bar, DJs, photo booths, and ice luges. Plaintiff has a video on her phone of the two of them simultaneously doing shots, and she has a picture from the photo booth that shows Bryant kissing on her cheek. Bryant was known to hire women in their early 20s who regularly hosted parties and retreats for his employees that included excessive drinking. Bryant often sought plaintiff out at work parties and invited her to events where alcohol was served. Plaintiff got intoxicated at the Christmas party. Bryant took her home in an Uber. Plaintiff remembers waking up in the back seat of an Uber with her head in Bryant's lap, and he was kissing her. When the Uber dropped plaintiff off at her house, Bryant followed her in and got into bed with her. Plaintiff's roommate heard plaintiff come in, and she went into plaintiff's room to check on her. She saw Bryant lying next to plaintiff with his arms around her. Plaintiff's roommate saw that plaintiff was intoxicated. She recognized Bryant as plaintiff's boss and knew he was much older than plaintiff. She also knew that plaintiff was not romantically interested in Bryant, who was her boss. It appeared to plaintiff's roommate that Bryant was attempting to have sex with plaintiff. Plaintiff's roommate yelled at Bryant and told him he needed to leave. When Bryant didn't immediately get up to leave, she screamed, "Get the fuck out of our house." Bryant finally left. In February 2019, Bryant invited plaintiff to attend several parties with him the night of the Super Bowl. In March 2019, Bryant told the plaintiff that his date was on a concert with him. Plaintiff went with him to the concert. When plaintiff worked for Bryant, she struggled financially because her starting salary was only $28,500. Plaintiff and the other employees were regularly required to work 60 hours a week. They were not paid overtime compensation. When they worked over 40 hours a week. Plaintiff had to get a second job waiting tables so that she could pay her bills. She was often exhausted from working long hours for Bryant's company as well as holding a second job. In April 2019, plaintiff asked Sean Moffitt, her manager, for a raise to $35,000 so she would no longer have to have a second job. Moffitt refused to give a raise. Since Bryant purported to be plaintiff's friend and plaintiff had previously been his personal assistant, plaintiff complained to Bryant about Moffitt's refusal to give her a raise. Believing Bryant would speak up to Moffitt on her behalf. Since plaintiff had previously worked as his personal assistant and Bryant knew she worked long hours, was a good employee, and was struggling financially, she expected Bryant to give Moffitt the go-ahead to give her a raise. That didn't happen. Several months after she resigned, plaintiff learned that another former employee had filed a class action suit against the company. Bryant and Moffitt alleging wage theft, seeking unpaid overtime. The plaintiff joined the lawsuit because she believed she was entitled to be paid for the overtime hours she worked, as Bryant, Moffitt, and the company profited at her expense as well as employees' expense by violating labor laws. On the same day that plaintiff joined the lawsuit, Bryant sent her the below indignant messages via Telegram and Instagram insinuating the plaintiff betrayed him, and it's in the complaint. Bryant's brazen messages indicated that he was confident plaintiff had no knowledge or indication of the crimes he perpetrated on her while she was unconscious, leading plaintiff to believe that she might have been drugged. When plaintiff didn't respond to Bryant's text, he had Bowman contact plaintiff via Facebook with veiled threats to publicly embarrass her if she didn't drop out of the lawsuit. Bowman told plaintiff he had, quote, security footage of her, quote, smashed at his house, and he insinuated that the video would be used to discredit her if she didn't drop out of the lawsuit. Plaintiff took this to mean that he had video of her falling into the pool because she vaguely remembered Bryant and Bowman filming her on their phones as she was climbing out of the pool before she blacked out. Plaintiff messaged Bowman that she didn't know why anyone would want a video of her drunk and falling into his pool, and she told him, you do what you gotta do, and she remained in the lawsuit. Several days after Bowman contacted her, Osborne randomly texted plaintiff to ask how she was doing, even though she had not heard from him in several months. Plaintiff took this to mean that Bryant instructed Osborne to contact her to persuade her to drop out of the lawsuit because on information and belief Bryant, Bowman, and Osborne were on a ski trip together at the time. Plaintiff had no reason to believe at that time Bryant, Bowman, and Osborne sexually assaulted her while she was unconscious and had video of the assault along with photographs of her private parts. The judge conditionally certified a class and granted summary judgment in favor of the plaintiffs against the company and Moffat in the wage case. Bryant asked the court to dismiss him from the wage lawsuit to avoid individual liability. I'm going on down to page 13, midsection under Congresswoman Mace. Line 90. In May of 2022, Bryant got engaged to Mace. On October 30th, 2023, a blogger contacted Mace and told her that Bryant was on a dating website called The League. At first, Mace didn't believe it, but a total of 3 women came forward reporting seeing Bryant's dating profile. Mace confronted Bryant about infidelity and asked him to go to counseling with 2 of her pastors. Bryant agreed. The pastors told Bryant that he needed to build trust, and to do that he would need to give Mace access to his phone. On November 5th, 2023, Bryant allowed Mace to access his phone with her thumbprint. That evening, while Bryant was sleeping, Mace checked his phone. What she found on his phone was worse than anything she could have imagined. In addition to finding the video of plaintiff being sexually assaulted while she was unconscious, she found images, photos, and videos of other women's private parts that appeared to be taken without their knowledge. On December 14th, 2023, Mace met with the FBI and the United States Attorney's Office, and she reported that what she found on Bryant's phone. They requested that the South Carolina Law Enforcement Division investigate the matter. As of the filing of this complaint, SLED is still investigating this matter, and no charges have been filed in connection with Mace's report. Mace was haunted by the video of the young woman who was sexually assaulted while unconscious. She was unsure of the woman's identity. However, she recognized the home in the video as Bowman's because she'd been there on prior occasions with Bryant. Initially, Mace thought the woman in the video might be Jane Doe Witness. In January 2024, she contacted Jane Doe Witness to inform her about the video she had found on Bryant's phone. Jane Doe Witness told her she was not the woman in the video, but she remembered what happened that night. Although she was still scared of Bowman, Jane Doe Witness had no longer lived with Bowman, so she felt safer discussing with Mace what she'd seen on the cameras that night. She told Mace that she had a diary entry and screenshots she had taken from her phone. Mace told her she needed to report what she saw to SLED and give them the email and screenshots. Jane Doe Witness later met with SLED investigators. Mace, still haunted by the video, wanted to find the young woman. Jane Doe Witness knew her first name but was unsure of her last name. The 2 women worked together to find her. Jane Doe Witness found plaintiff's last name on social media a few weeks later. Mace contacted someone she thought might know plaintiff and asked if he would reach out to plaintiff and ask her if she would be willing to talk to Mace about Bryant. He agreed. He called the plaintiff and asked if she would speak with Congresswoman Mace. He told her that Mace had called off her engagement with Bryant and wanted to speak with her about Bryant. Plaintiff told him she wasn't sure what information she could possibly provide, but she was willing to talk with Mace. Mace called plaintiff on April 6, 2024. Mace asked plaintiff what she remembered about the night she was at Bowman's house. Plaintiff thought it odd that Mace was asking her about that night. She told Mace she was very intoxicated and blacked out. She said she remembered going to Bowman's house with Brian and falling in the pool, but she didn't remember much after that. Mace told her that she found a video on Bryant's phone of her being sexually assaulted by Osborne while she was unconscious. Mace also told plaintiff about the Stop Boyers Act 2024 at the time and that she was working to prevent what happened to her from happening to other women. Plaintiff felt her stomach drop and her body felt numb. She was in disbelief. She couldn't believe what she was hearing. She started panicking. She couldn't process what Mace told her. Plaintiff experienced immediate shock and psychological trauma. She had no prior knowledge of the assault or that such a video existed. The revelation was devastating. Plaintiff felt disoriented, violated, and betrayed. The emotional impact was acute, including nausea, confusion, disassociation, and overwhelming fear. The knowledge that someone she dated did this to her and that trusted professional and interpersonal acquaintances planned and reported this act compounded her trauma. Plaintiff did not discover what the defendants did to her until Mace told her on April 6, 2024. Plaintiff did not know or have reason to know that she had the legal claims outlined in this complaint until April 2024 because she was unconscious when the defendants violated her. Plaintiff texted Mace the following day and asked Mace if Mace would talk to her again, as she could not process what Mace had told her the day before. She and Mace spoke again the next day. Plaintiff asked Mace several questions. During the call, plaintiff became hysterical. In the months that followed, the plaintiff met with SLED investigators. Mace called her frequently to check in and see how she was doing. Plaintiff told Mace she was struggling emotionally and that she struggled to cope with what the defendants did to her. Although she's not certain, Clayton believes it was likely the defendants drugged her because she has no memory after a certain point. Also, how else could the defendants be certain she wouldn't wake up during the assault? Moreover, after the assault, the defendants were confident that plaintiff had no memory of what they did to her, which seems unlikely unless they knew she was drugged. In February, Mace informed plaintiff about a speech she planned to give in support of the legislation. A few hours before Mace's speech, Osborne left plaintiff a message on LinkedIn asking her if she knew what was happening in Washington that night. Plaintiff's blood went cold when she saw the message. She never responded. Upon information and belief, Osborne sent a similar message to Jane Doe witness. On April 28, 2025, one of Bryant's lawyers sent a 5-page letter to the plaintiff, the individual who had reached out to the plaintiff on Mace's behalf, Jane Doe witness, Mace, and 2 former co-workers threatening to sue. Then on May 7, 2025, Bryant carried out this threat by filing a lawsuit against plaintiff for breach of contract on behalf of the company that committed wage, claiming that plaintiff violated the settlement agreement in the wage lawsuit by making disparaging comments about Bryant, even though the court granted his motion to be dismissed from that action. Bryant asked the court to grant him a restraining order precluding plaintiff from making disparaging remarks about him, notwithstanding that the agreement does not preclude plaintiff from making truthful statements, and the settlement agreement only pertained to the wage claims. Moreover, the settlement agreement was never intended to shield Bryant from committing sexual battery or from taking photos of plaintiff's private parts without her knowledge or consent. Bryant is using his vast financial resources to intimidate the plaintiff and discourage her from testifying against him in both criminal and civil proceedings, and is using the legal system for an improper purpose by filing a breach of contract lawsuit against the plaintiff. Bowman has attempted to silence plaintiff by defaming her and publicly shaming and humiliating her. Bowman published her first and last name on X under his username Not Eric B. He referred to plaintiff as a drunk and insinuated she's lying, promiscuous, and has a psychological disorder. Bowman has maliciously shamed and embarrassed the plaintiff and destroyed her reputation. Bowman has posted a 4-second video on X that he took of plaintiff soaking wet climbing out of his pool. Bowman also provided the video to the Daily Mail, who published the video with the plaintiff's face blurred. Bowman provided the Daily Mail with the plaintiff's full name and cell phone number, along with several photographs of the plaintiff and videos of the plaintiff climbing out of the pool to harass, shame, and intimidate plaintiff. Bowman and Bryant's actions violate South Carolina Code Annotated 16-3-730, which makes it a misdemeanor to publish or cause to be published the name of an alleged victim of criminal sexual assault. While the Daily Mail did not publish plaintiff's name, they did publish pictures of plaintiff that blurred her face and published Bowman's statements in an article. This goes on about Bowman and social media and the posts. The bottom of page 18134, Bryant and Bowman were acting with malicious intent by providing the Daily Mail with close-up photographs of plaintiff climbing out of the pool to publicly humiliate, shame, and intimidate her. Bowman and Bryant sent the video and pictures of plaintiff to the Daily Mail to embarrass and discredit her. Ever since Bowman revealed the plaintiff's identity on X, she's received calls and texts from reporters at CNN, the Daily Mail, asking her to comment on the allegations. These calls have disrupted her life, caused her anxiety, and plaintiff is afraid to answer her phone as is scared reporters will show up at her home or place of work. As a result of what the defendants did to her, plaintiff has experienced severe emotional distress. She suffers from panic attacks, crying spells, and anger outbursts. Plaintiff had to take time off of work to prioritize her mental health and seek therapeutic support. The emotional fallout has been ongoing, impacting both her personal and professional life. Plaintiff becomes frightened and anxious every time she sees a man holding a cell phone picture. Plaintiff has nightmares and frequently wakes up screaming. On various occasions, friends have told plaintiff they heard her scream in her sleep. On a work trip, a co-worker in a hotel room across the hall texted her to see if she was okay after hearing her screams through the hallway. Plaintiff frequently experiences hypervigilance in both public and private spaces, scanning for hidden cameras or men with their phones out. She finds herself scanning for hidden cameras or recording devices everywhere she goes. She struggles to interact with males at her job. Plaintiff could not finish her thesis in graduate school and had to ask for an extension and is in counseling. Defendant's actions against plaintiff were willful, wanton, and done in reckless disregard of her rights. The defendant's conscious failure to exercise due care constitutes willfulness. Therefore, plaintiff is entitled to punitive damages. And then the motion, the complaint goes into the causes of action, which you can download. There is also a motion that was filed today by her attorney. It was a plaintiff's motion to proceed under a pseudonym, and you can get that online as well. There were two things. On page 1, I wanted you to notice. And here it says the plaintiff, through her undersigned counsel, respectfully moves this court for an order granting her to proceed under a pseudonym, and the lawsuit filed contemporaneously with this motion for the reason set forth below, and there are several factual allegations in here. Plaintiff Jane Doe is an alleged sexual assault victim in a case that has garnered national attention since Congresswoman Nancy Mace gave a speech on the floor of the U.S. House of Representatives stating that she found a video of on her then fiance Patrick Bryant's cell phone of a young woman being sexually assaulted while she was unconscious. Plaintiff is one of the women that Mace is referring to in her speech. On page 7 of the same motion, I wanted to bring special attention to where the attorney writes in her motion that Bryant is using the court system to conduct a fishing expedition into witnesses' private lives. It appears Bryant created the company GLT2 LLC, which is registered with the South Carolina Secretary of State, February 20th, 2025, 10 days after my speech. For this purpose, this company has clear ties to Bryant because the registered agent for GLT2 LLC is the accountant for Assignment Desk Works LLC, which is the company that has filed the breach of contract lawsuit against the plaintiff. Additionally, the law firm representing GLT2 LLC also represents Bryant in several matters. On February 21, 2025, GLT2 LLC filed a petition in Charleston County Court of Common Pleas to authorize depositions and discovery before filing a legal action. The petition names GLT2 LLC as the plaintiff and Jane and John Doe as defendants. In GLT2 LLC's court filing, the company provided no information about any potential claims it may have against Jane and John Doe. GLT2 LLC then deposed Wesley Donahue, who was a longtime friend of Bryant's and a former political consultant for Congresswoman Mace. GLT2 LLC began conducting depositions despite the court not having yet heard its petition, nor has the court filed an order authorizing them to conduct depositions. The matter is scheduled to be heard on June 4th, 2025. During the deposition, Donahue made numerous disparaging comments about Mace, both personally and professionally. GLT2 LLC then provided the transcript of Donahue's deposition to the media, which was published by Fitz News on May 21st, 2025. Clearly, Fitz received this from GLT2 LLC as they are the only named party in this matter. The court should grant this motion to protect plaintiff because it appears Bryant is creating companies to exploit the legal system for an improper purpose, namely to conduct depositions in a case that has not been filed and release them to the media to publicly embarrass, discredit, intimidate, and or discourage witnesses from testifying in any civil or criminal proceeding against him. Plaintiff is also fearful of her personal safety. Although she resides in another state, the defendants are wealthy and possess substantial financial resources. Bowman has a history of engaging in violent behavior. He was arrested on April 8, 2025 and charged with harassing Jane Doe witness who was a witness in this case. Bowman also was charged with assaulting a man with his golf cart in 2018. The man was severely injured and a jury ordered Bowman to pay $1.8 million in actual damages and $2.7 million in punitive damages. Regarding the third factor, which involves the age of the person whose privacy interests are sought to be protected, the plaintiff was 23 years old at the time of this occurrence. Since the assault, she's enrolled in graduate school and hopes to have a successful career in her chosen field. Publicly identifying her would have long-term implications for her career prospects, given that she's only at the beginning of her career and is not established in her field. These can be downloaded online. Right now, if you haven't already, my staff is releasing my statement, which I'm going to read for you today. Today, a brave survivor of rape and sexual exploitation filed a civil class action lawsuit against three men mentioned in Congresswoman Nancy Mace's February 10th floor speech: Eric Bowman, Patrick Bryant, and John Osborne. According to Congresswoman Mace, the victim, after being incapacitated, was sexually assaulted, and the assault was filmed. The video was saved and stored for more than 5 years after. All of this happened without the victim's knowledge. The lawsuit seeks to hold the perpetrators accountable for the premeditated and deeply traumatizing assault. Congresswoman Nancy Mace, who originally uncovered video evidence of the assault, issued the following statement: "This young woman didn't know she was raped because she was unconscious when it happened. I told her the truth after finding the footage. It was one of the hardest conversations of my life. Her strength in coming forward is immeasurable, and I will stand with her, under oath, every step of the way." According to Congresswoman Mace, the victim was raped at a property owned by Eric Bowman on Sullivan's Island. Patrick Bryant and Eric Bowman sat by with their phones out while John Osborne carried out the assault. As revealed by Congresswoman Nancy Mace on her floor speech on February 10, 2025, this assault was premeditated and orchestrated while children were in the home. Mace accidentally uncovered the footage in November 2023. What she discovered was staggering: video of the assault, photos of the victim, and corroborating metadata. She would eventually identify the victim and inform her of the assault. Mace turned over what she uncovered to law enforcement. Quoting again, "This isn't just about one woman. This is about predators who have operated with impunity for far too long. The lawsuit filed today is only the start, only the first step towards justice for her and others. It's proof predators can be exposed, that truth matters, that survivors have power, and that justice isn't optional, it's long overdue. When this system fails to protect victims, it's not just broken, it's complicit. Every woman harmed by predators deserves justice, and if our solicitor and our attorney general won't fight for them, I will. To other potential victims of these predators today, I have a message for you. I want other potential victims to know that I have your back. I outline in my statement about a dozen bills I've worked on. I started with the Sue Voyeurs Act and the Stop Voyeurs Act as soon as I uncovered this footage. I thought it was unreal that women, in the Violence Against Women Act, there really were no protections for women who were victims of voyeurism. There was no criminal act under Title 18. The Federal Code of Laws, voyeurism is only illegal under Title 18 if you're in certain maritime jurisdictions or tribal lands. Think cruises or tribal lands. There is no, it's not under, it wasn't a violation, I found out, under federal law to film women in this way. And so I created a bill, the Stop Voyeurs Act, that would expand the very narrow criminal prohibition against video voyeurism at the federal level. I also filed another voyeurism-related bill called the Sue Voyeurs Act. VAWA created a civil tort or civil right of action for revenge porn. It did not create a civil right of action or civil tort for voyeurism, so that bill does that. I have lots of different, several different bills regarding rape, regarding deep fakes. I have a bill I just recently refiled that would not allow rapists to sue rape victims. That's what's happening in this case. The justice system, predators in this particular case are using the justice system to harm victims and to harm witnesses. And so with that, Sydney will pass out the statement, and you can download this motion and the complaint. It was just filed in the last hour or two. Thank you. I'm not going to take any questions.
Thank you guys so much. Yes, so I'm happy to hand everyone out a printout if they need. Also, if you haven't met Carly yet, I'd love for you to introduce yourself. She will be probably your best point of contact, but always feel free to contact me as well. We also have Kate from our team. We're super happy to have her. Let me go ahead and give you guys those handouts on your way out.